R3 morning, we got R4 night.
All right.
R5 no reply.
All right.
Honorable Governor no reply. Now, let's, of course, if I go on, then it has to be without prejudice to dealing with any rejoinder which counter which closes. That's the
point. Yes.
I mean, it's not my fault, but it's an odd procedure. My lord is kept the whole afternoon, etc. Two of them have not filed a reply. R5 is not, and the governor is not.
No, if you want to go on, you can.
I
Not
appear
yes.
on behalf.
Yes.
Now, I am appearing on behalf of the learned Solicitor General.
On behalf of,
I will do this, Balats, that I can go on for a while, and in the light of any reply they make orally, in the meanwhile, I'll have to file a rejoinder in any case. I'm not.
That's exactly.
Because otherwise,
See,
I will be the one prejudiced because they gave me reply yesterday night.
So there are some.
not yesterday.
If objections, wait, sir.
Please.
If objections are filed and which would necessitate a rejoinder, then you may as well do it. If you want to submit, submit, no problem.
No, therefore, Malas, I was really advised to do a dual procedure if it is possible. I've not done it normally.
Right.
I argue for a while, Malas.
All right.
But in case I have to deal with, I mean, there are so many things they've said here. So obviously, Malas, I'll have to have a right to file that in the course of, Malas, whatever the next date of hearing, etc. Because otherwise, Malas, I'd be prejudiced. And in any case, two parties have not filed anything at all.
That's the governor and
R5.
But on behalf
Another
of R5, let me make the position.
R5 complainant.
Complaint, respond number 5.
All right.
But I have examined the petition copy
Huh.
and the annexures which have been filed along. Insofar as our the arguments are concerned,
Huh.
we will be relying upon the documents which they have filed along with the writ petition.
So you're not filing
There is
any
nothing else for us.
You're
to
not
file
filing
on
any
nothing
objections.
else on record.
That should be recorded.
Insofar as we are concerned,
One is over.
questions of law have been raised and the documents have been filed along with the statement, writ petition. We will
All right.
be relying.
All right.
But as far as the learned governor is concerned, if I may interject, Malaz, I am appearing on behalf of the learned Solicitor General.
Huh.
Since a question of law has been raised, the office of the learned governor will be assisting this court on question of law. If required, my lords, we will produce the file of the honorable governor which led to the decision making. My instructions are to state that as of now, we are not going to file a reply and we'll assist the court on
Yes.
the questions of law raised. We'll file written
All right.
submission during the course after hearing Dr. Signi's submissions.
Only
Our
delete
only
the word.
submission is that the hearing should not be delayed, my lords. My lords
No,
were
wait. Yes, sir.
Only delete the word as of now.
Please, my lords, the statement.
One line was required. I'm not filing a reply. I've noted that for both R5 and for Honorable Governor.
R5 and
Malaz may
Caveats
respond-
as of now, etc.
But in all fairness to the petitioners, they have produced practically every document possible which led to the decision of the Honorable Governor.
All
Therefore, Lord, will be relying
I'm so happy that I've
No, I
obviated
must say,
a
I must say,
counter.
no, when I said that, but I meant it. I meant it in all fairness. They have produced everything possible.
No, I am also taking it as a compliment that my comprehensive petition has obviated the need for counter from at least two parties.
No, I'm talking of the documents
So I
which have been
think if
produced.
those two are not filing the objections and
And in the course of whatever the next date is, I'll file the rejoinder to the other two. Malaz.
if you want to submit, you can submit.
Yes, yes.
Yes.
So, Lordship, I recall, Malaz, there are no replies from these two because I don't want to be ambushed later on this.
Yes,
point.
that I will
It will
record.
be said later on that is unrebutted allegation, this, that, etc. I don't want that. Malaz. I want to be.
I will record the submissions. Yes, let me just record that. The learned senior counsel, Sri Prabhulinga Navadgi, representing the fifth respondent, would submit that they have no objections to be filed in the case at hand as the question, as what revolves around the present challenge is pure question of law. He would further add that all the documents that are necessary to be relied upon is already produced by the petitioners and no further documents would be required. The learned counsel representing the Solicitor General, who represents the second respondent, would also submit that since pure question of law is involved in the case at hand, no objections need be filed, but the file relating to the grant of approval under 17A would be produced for a perusal of the court. That's your submission, right?
Please, Malaz.
Yes.
That's right.
Now you can. Yes.
My third statement that I have received these other two.
The learned senior counsel, Shri
Came for one yesterday.
Abhishek Manu Singhvi, representing the petitioner, would submit that the objections filed by R4 and
R4. 3 and 4.
R3 and R4
Yeah.
have been served upon them, one of which is served the 48 hours ago and the other about 24 hours ago. Therefore, he would seek, in case a rejoinder is required, he would file the same in due course. The submission is placed on record.
Would my lords also record that we will be filing written submissions on points of law?
On points of law, all right.
Yes.
The Ali second respondent idiyalla, Ali. The learned counsel would submit that written submissions with regard to the point of law would be filed in due course. Yes.
Same with
well,
me as well.
Ibardu ade ಹಾಗೆ. Both, yes. Yes, sir.
Now, let's on just to go point wise and to focus on the narrower issues, Malas, because ultimately,
Have you filed any synopsis, written submissions or something, anything?
Malas, I was actually frankly waiting for the counters and I would have covered everything in a comprehensive thing. So I
Okay.
will, when I file my rejoinders, I will put in written submissions also.
Yes, sir.
But Malas, I thought I'll deal with all together. So I was waiting.
No problem. Yes.
Now, let's, your lordship may just consider this point by point. Your lordship remembers I started last time with 17 capital A
Yes.
when I came.
PCI.
Now, let me break up some of the interesting facets of 17A, which I submit by itself. I don't want to oversimplify. I don't want to exaggerate.
Yes.
By itself, this one point would be sufficient to allow the petition without oversimplifying. And well, it's fortified significantly by the replies we have received. The replies we have received are very interesting. I would, in fact, I don't want to sound facetious. Were it not a serious case, the replies make it quite comic and make it very interesting and make out my case completely. And on the basis of the reply, not that I'm asking Lordship to decide on the basis of reply alone, on the basis of reply alone, this petition can be allowed. Let me explain why. 17A first. Now, my first point when I opened last time, without the benefit of replies from R3 and R4, which we received yesterday, etc. The point I had made was that 17A needs prior approval. A, let me break it up point wise. B, prior approval is mandatory under your lordship's established several judgments. And C, the textual ingredients of 17A, leave aside anything else, even the textual ingredients of 17A were ex facie not satisfied, and yet the governor has granted sanction. Two of the textual ingredients of 17A not satisfied were only on the application of an investigating agency / policeman. That is one. There is no application by any investigating agency or policeman in the present case. And that I submit is a condition precedent of a mandatory provision of the textual language. And the second was that it must relate to a decision taken or a recommendation made by a public servant. Now, these two ingredients follow from 17A. Your lordship saw it last time with me.
Yes.
No police officer shall conduct any inquiry open with police officer or inquiry or investigation into any alleged offense alleged to have been committed, where the alleged offense is relatable to any recommendation made or decision taken by such public servant. So opening is police officer or investigating agency, and recommendation made or decision taken is the second ingredient. Both are not only admittedly not satisfied, not invoked, cannot be satisfied, cannot be invoked. They don't arise. And the public servant here has neither made any decision nor any recommendation in any capacity as CM or Deputy CM, etc. This is my first point.
Right.
Your lordship would see my law index alone. I'm surprised, all the cases, this is worse than carrying coal to Dhanbad. All the 3 judgments I've got, I did not realize it till I saw them.
Yes.
Are, I believe, authored by your lordships. So I'm not going to actually carry coal to Dhanbad. But your lordship see the law index. There
Yes.
are 3 judgments cited by me in the opening.
Yes.
The first proposition is Ashok versus Lokayukt. Second is Yashwant Sinha versus, not that.
That's Supreme Court.
That's the third one, Shirupa. And most important, fourth one, Praveen Kumar.
Fourth one was the first one. Rendered.
That's right. That's right.
Yes.
This put wrong in the serial. Now, these ballots make it clear that this is mandatory, this is clearly necessary, and that it has these ingredients. Well, the relevant para of this Praveen Kumar is para 14 to 16.
That is with regard to application of mind. Yes.
And it said 138 ballots. Would my boss want to read it? Because I don't think it's necessary. The Lordship has seen that
Yes.
these are not ballots altered, appealed, challenged in terms of what variation. I don't know if the
No, I
challenge or
think
not.
these judgments have become final.
Final. I mean, but certainly not varied in any manner. I don't know if they're lying in some challenge here or there, but they're not varied
Yes.
in any manner. The Srirupa is para 23 to 28.
Yes.
That starts in my compilation at 106.
Yes.
And the third one is Ashok, para 15, which
Yes.
starts at page 5 of the compilation. First point, ballots, the language history. Second point, the 3 cases. And 2 additional points before I come to what has happened now, which is very, very interesting, virtually almost comic. The circular at 260 of the paper book, which is the circular of the Honorable High Court of Karnataka at 260.
That is implementing Ashok.
So that your Lordship has noted. And then, Malaz, there is a SOP, a procedure
Of the Government of India.
of the Government of India dated 3/9/21 at page 703.
Yes.
Which my Lord saw with me last time, para 2 and 3.
Yes.
These were the 5 points I made in the opening, QA 17A. Now, there is something interesting, a lot of interesting developments on 17A alone. We stick to 17A for the time being. And your Lordship will note those developments. One of the, I would say, the principal complainant, if I may give him that special
Title.
post and position. I mean, even amongst complainants, there should be an hierarchy.
All right.
The principal complainant has now filed a reply saying
Now,
that
which respondent are you addressing?
R3.
R3. Who appears for R3? Aniva.
Everyone.
Right. Yes. R3.
Reply, which I'll be presently reading in a minute, says variously. There is itself is a bit of a fudge, but and I'll take it both ways. He says no 17A is required. And then he adds 1 or 2 places, just a word. He says unconditionally no 17A is required. I'll read that verse in a minute. And then he says not required at this stage. So he takes both, please.
Objections. List of citations.
I will take it either way.
Stand.
Objections of R3.
Yes, it's here. Yes, sir.
If your Lordship will turn to that verse in particular at page 60 and 61, and I'll take the liberty of reading this a little slowly. Para 20 at 60.
Yes, sir.
In the private complaint filed before the special court, the stage of court taking cognizance has not yet reached. And R3 in his private complaint has only sought for reference to the concerned investigation officer for investigation under 156(3) of the CRPC in accordance with law. Therefore, the question of taking cognizance at the current juncture does not arise before the special court. It is submitted that on this ground also, R3 need not obtain sanctioned as envisaged and 218. Currently, the private complaint, which is an unnumbered one, is posted for hearing before the special court. Nevertheless, the R3 applied for sanction. Mark this word. Nevertheless, R3 applied for sanction to the governor in adherence and compliance of the honorable judgment in Ashok, as the same is currently the law of the land, as an adherence exercise and a procedural formality, not any substantive requirement, a procedural formality, pursuant to the circular issued on 4th of July. Now read the next 4 lines.
Yes.
Although the order of sanction from the competent authority under 17A is not required for the instant case, and the sanction under 218 is not mandated at this juncture. Now, Milits, I have 3 or 4 points here. and I don't want to sound facetious, the whole of writ should be allowed, or he should withdraw his complaint, rendering the sanction complete waste of time, and the governor should first impose costs on him. And then later on, your lordship should impose costs on him. Your lordship, why? I'm not making a facetious comment. Now, this person, your lordship, read his pleading. It's on solemn affidavit filed in the court, given to us yesterday, day before. That's why I said, were it not serious for me, it would be comic. This person, Malaz, like Alice in Wonderland, applies to the Lokayukt. The same person. Please turn to Malaz. Sorry, Malaz, to the governor
Yes.
at page 48. Page
Oh, was it
48.
applied before the Lokaयुkt also?
Also,
Not
the
in
Lokayukt.
compliance with Priyanka Srivatsal's case.
I'll do that also.
Complaint was lodged.
First, come to the governor.
Complaint was.
Complaint was lodged.
All right.
Apparently, Malaz, the entire machinery must waste time on his vexatious complaints, which he says, I don't need to make a complaint application. Why should I trouble the Honorable Lokayukt and Honorable Governor? Come to Malaz, page 43 first. Sorry, 48 first.
Of the objections?
Of the Malaz, of the petition, of the paper book. Volume.
Yes.
Now, your lordship just read his affidavit. Now read this. His Excellency, the Honorable Governor, on 26th of July 2004, first line, request for sanction for prosecution of Mr. Siddaramaiah, etc., etc. And read the fourth line under 17A and 19 and 218 also, Malaz.
Yes.
Also, Malaz, end this at 69.
Yes.
Which is the last para. Wherefore, it is requested from your good office to directly grant sanction for the prosecution of Siddaramaiah.
Yes. What is this? Illegally gaining rupees 55 crores, is it?
Where is it written?
No, the complaint is about that.
Please.
55
Yes,
crores.
yes.
Application for sanction.
He makes a
is about that.
quantification of this whole issue and says this is illegal. At the moment, we are on his affidavit
That's
and we
all.
are on this. Right? Malaz?
60.
Now, again, this is not just a single Malaz swallow in the summer, not a single bout of madness. It is a consistency. Page 200. Same volume. This is the Honorable Lokayukt.
So this is to the Lokaयुkt. This is 154-1 complaint.
Please.
Yes.
Information of so and so, so and so. Where is it? Why did you give me Lokayukt? Does it have?
Yes.
Does it mention sanctions? You have to give me only when it's sanctioned. Now, whereas here he has made a complaint where he does not say anything about 17A. Is it there? Oh,
No, this is only a complaint. It is-
complaint, correct.
It need not comply with 17A in this.
No, I'm just saying, Wallace, he's
Ah,
come all
yes.
this way to the governor, etc. He makes no mention about anything.
Yes.
Now,
This is earlier to the governor's.
that's right.
Clear.
That's right. Now, Wallace, Wallace, put it like this. He has made a complaint. He seeks sanction. Governor grants sanction. It's not a suo motu governor action. The governor action is based on on XYZ's complaint. That complainant says not necessary. Well, then, Malaz, obviously, since he will not withdraw it, your lordship should, Malaz, treat that application for sanction as non-existent on this basis alone, on the counter affidavit.
Hmm.
And therefore, the basis and the foundation of sanction goes. We are not here to answer academic questions. We are not here to, Malaz, the entire foundation of the sanction order goes. And this is not, Malaz, this is Malaz, a person who is facing this like me, the petitioner, has every right to say this is absolutely a farce. I didn't mean it lightly when I said the governor should, before sanctioning prosecution against me, impose costs against him. If he has the power, certainly your lordship has the power. I don't know if the governor has power to impose costs, Malaz. So this is the short point on which on the second aspect of 17A, And it's a full point, Parod, I submit with respect, that this cannot be just that you come to system, you set a whole thing in motion, and then you say not required at all. Well, then you have to take you have to be straight in your stand. You take your chances. What is the problem? You go ahead, prosecute, we'll see whether a sanction is required or not. You can't have it both ways. You get a sanction, when I come to court, you tell the court in the counter affidavit, I didn't require a sanction.
So you mean to say that they can proceed with it without sanction?
They should. They should, Balas. They should have the courage of their convictions. I'm not saying anything. I'm only defending. Imagine, Balas, that's why we say, Balas, that's why. No, there's another facet to it. In practical, not in law also, Balas. People like the governor should be restrained. That's what happens when anybody walking down the path makes an application. Well, should not the governor have said that you don't require sanction? If you applied your mind. I'm not saying he would have or should have. Well, if anybody on the road comes to him and says, give me sanction. He's so eager to give the sanction, the man himself says, no, I don't need sanction.
No, but approval under 17A is not sought prior to all actions. It is when the court proceedings were on, I guess, after the complaint being before the court.
Yes.
The approval is sought at the hands of the governor, not before that.
No, it's
When
so-
was the complaint registered?
First, the sanction was sought.
Amal complaint registered. All right.
Right at the threshold. And your lordship, 3 mandatory judgments are prior sanction. So, Malas, this is Malas very serious. He's playing ducks and drakes, A, with the governor, who has actually granted his prayer, and B, with the court. And Malas, the only legal consequence of this is, of course, I'm not saying that he is going to withdraw. Should be his withdrawal on the basis of his affidavit. He can't, Malas, the affidavit prevails. Perjury prevails on an affidavit. He can't be perjuring himself by filing the affidavit before your lordships. So on that affidavit, he must withdraw. Otherwise, your lordship should, Malas, treat that as non-est. The moment it becomes non-est, the sanction goes. So that's the ground for the sanction to go. It's not a suo motu sanction.
No, it's not.
Now, Malas. Now, the other person, like Alice in Wonderland, gets curiouser and curiouser. That is the phrase used, Malas, in that book. It's quite remarkable what happens in the other case. That is Mr. 4, R4. Well, he has got sanction also from the governor. Your lordship has got an order. The final order mentions, suddenly, notice came to me only for R3. That's why
I know,
actually
I know.
this is.
A
Then
particular
4, 5
paragraph
also.
mentions these two as well.
These two also. So the governor is purportedly applying might to 4 and 5 also. But it now transpires that R4 never sought sanction. The other fellow says, I need not have sought sanction, but I did. I hope I'm clear. If you actually examine R4's complaint, which has now come to me, and I'm going to ask my learned friends better equipped in Karnataka to read it to your
Maybe
lordship.
some restraint, my lord, on
Wait,
usage
wait.
of words.
When sin is submitted, wait.
I'm going to ask you to read it.
Anything I'll ask you.
No, my lord. On usage of words, my lord. There may be some restraint.
About
my lord.
what?
Some fellow, Alice in the
that-
Wonderland.
yes.
My lord,
Sorry.
it's not, my lord, there's no impediment for me to use such words.
Yes.
But protecting the sanctity of this honorable
Yes,
court
yes.
is utmost important.
If
The-
literature of
I-
Alice in Wonderland
No, revenue
standards
code,
are
my lord.
objectionable,
No,
unparliamentary words, I
such
plead guilty,
language.
Willis. I
You may,
plead
you may
guilty.
address them as respondents, that's all. Yes.
Now, Willis, we are in a case where the first person says that I applied for sanction, but I need not have applied, which is sufficient to allow the sanction to fall.
All right.
The second person says, I never applied for sanction. Then how did the governor grant on
But
what?
he has not applied. That is a fact.
That's fact. Now, we'll just see that. Just see that at 376, his application. It's quite remarkable. 5th of July,
Whose
2020,
application?
R4s. To the governor, which is now, well, we have got only well, with this reply,
76 of what?
376 of R4's objection.
R4 objections, madam. R4 objections.
Well, I made them read it to me slowly, and I was happy to note that I could understand most of the slow reading of Karnataka. But I can't read it to your lordship, so my learned friend Mr. Ravi may kindly do the honor of reading.
This
just
is
the
this Snehamai Krishna. R4, is it?
R4. The last, just a relevant portion.
Just subject and
Yes.
the prayer.
First is the subject words. Yes.
76. 370.
Sorry, I should Kannada. I
All right.
wrongly said Kannadiga.
Read.
Kannada.
in your subject ನೋಡಿದೆ.
Apologies.
ಹಾ.
Kindly come to prayer.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
380.
ಅದೇ ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
Yes.
Hmm.
I'll read it.
Yes.
My learned friend is also able to understand Kannada. When they read it slowly.
No, I understood when they read to me slowly in conference. I understood most of it. I was happy to note.
Yes, sir.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು ನಾವು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ವಿಜಯನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನಾನು ನೀಡಿರುವ ದೂರರ್ಜಿಯನ್ನು ಆಧರಿಸಿ ಕೂಡಲೇ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಹೇಳಿ ಮಾಡಿ ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಮತ್ತು ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕರಿಗೆ ಸೂಕ್ತ ಆದೇಶ ಮಾಡಲು ಹಾಗೂ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ಪ್ರಭಾವ ಬೀರಿ ಮೊಕದ್ದಮೆ ದಾಖಲು ಮಾಡದಂತೆ ಮಾಡಿರುವುದನ್ನು ಸರ್ಕಾರಿ ಯಂತ್ರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸುಳ್ಳು ಮಾಹಿತಿಗಳನ್ನು ನೀಡಿ ತಾವು ಮತ್ತು ತಮ್ಮ ಕುಟುಂಬ ಯಾವುದೇ ಅಕ್ರಮ ಎಸಗಿಲ್ಲ ಎಂಬುದನ್ನು ಸಾಬೀತುಪಡಿಸಲು ಪ್ರಯತ್ನಿಸಿರುವುದನ್ನು ಗಮನಿಸಿದಾಗ ಸದರಿ ಪ್ರಕರಣದ ಮೇಲೆ ಮುಖ್ಯಮಂತ್ರಿಯಾಗಿ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರು ಪ್ರಭಾವ ಬೀರುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರನ್ನು ಕೂಡಲೇ ಮುಖ್ಯಮಂತ್ರಿ ಸ್ಥಾನದಿಂದ ವಜಾ ಮಾಡಲು ಕಳಕಳಿಯ ಮನವಿ ಮಾಡಿ.
Now, it's just this much shows I'm not interested in R4, who have not even filed. It shows complete non-application of mind of R2. Complete, total and absolute on that short ground, the sanction must go.
One clarification. No, 1 minute. One clarification. Here, there is, he is not seeking sanction at all here. He's only asking the matter to be referred for investigation to the hands of the CBI. And inter alia, he says that he should step down.
Correct, correct, absolutely.
So this is not a question of sanction at all.
Correct. He goes to the governor, governor passes an order on this. Sends me a show cause based on this.
No, show cause notice is not issued on this.
No.
Not on
No
this.
show cause notice is
Not
issued on
this.
this.
Then Malas, the order says I'm,
A paragraph
That's
refers
right.
to this.
that's right.
But no show cause notice
No,
is issued
no.
to you on this.
One of facts. This morning, along with a memo, we have filed a communication dated 31st of July 2024, which we have submitted, my lord, to the honorable governor, which seeks for sanction. Kindly see that memo.
When was that given?
31st of July. This is after this letter, another communication.
Governor's order.
That is what I want to point. So, my lord, to say
Governor refers to this, you mean?
by date, the governor, my lord, does not refer to it by date, but to say that no sanction at all was.
Why you did not file this along with the statement of objection?
No, Malas, I'm very happy. Please let them, Malas, oh, these webs we weave, we become Malas caught in them. Please record this. Kindly record this, Malas. This is an official statement. I'm not talking about counsel, I'm talking about his client. He says he did, so he said this is not, but I filed on 30th or 31st of July. Kindly record that.
Yes. No, anyway, it is getting recorded, not a problem.
No, what I mean to say is not record in that sense, but it's a stand now.
Yes.
Now, that 31st of July, so by my point till I heard Mr. Raghavan intervening was that there is complete non-application of mind by the governor. Now I hear him intervene, possibly to say, no, the governor did apply his mind. But my point remains the same. The governor in his sanction order does not recognize, mention or note 31 July, which I have heard for the first time 1 minute ago. So my non-application of mind is improved. Oh, these webs we weave. That is the point, Malas. That's what Shakespeare said. The more you weave a web, the more you get caught in it. So, to try and cure the lack of application of mind by the governor, a statement is made that we did give him a sanction application. The governor doesn't notice that sanction application in the order sent to me and does not issue me show cause on that.
No, all that the governor says at paragraph 2 is
Yes.
2 more petitions from Pradeep Kumar SP and
Yes.
Snehamai Krishna
Yes.
have been received at my office in respect of the same allegations.
So,
So
Malas,
date is not mentioned,
three
nor
things,
the
three
content is
things.
mentioned. Yes.
we do not know when given, how given.
So that's what now
Don't
is
know.
sought to be produced.
Now it is produced. It is quite astonishing, to put it mildly. That's my third sub point here. It is more than astonishing that a man who files a 100-page rejoinder forgot to say this in his counter, forgot to say this in his counter. At the moment, Malas, I'm trying to use words of studied moderation. We have all been, Malas, we are lawyers. Your Lordship has been a lawyer. There are lawyers all over the place here. A person who files a counter yesterday or day before has omitted to mention Hamlet in the Prince of Denmark or Prince of Denmark in Hamlet. This is his complaint, this is a foundation. Till now, we don't know about it. Your Lordship doesn't know about it. Realizing that he is apparently curing the governor's defect, but not realizing that the governor doesn't tell your Lordship whether he's acting on this complaint which I have read just now or the 31st July complaint. It is quite unclear. He has not, Malas, why should I not say that he acted on the complaint I have read to your Lordship and not on this? Why should I not say it? And why is it not fortified by the fact that the first time this has been mentioned is on the 29th of August in the middle of arguments? Well, it's 31st July. When did I argue the matter first? I argued it was 1 week ago, I think. 19th August. 31st July, 19th August, 29th August. In between on 27th and 28th August, counters are filed. Well, there are 4 occasions. I'm sorry, Malas, I'm being a
So
little...
let's see whether the omission would cut at the root of the matter.
It would, Malas, because this is a Malas. Your Lordship takes a holistic view. No single straw breaks a camel's back. But Malas, this
Yes.
is very, Malas, to put it in the mildest word, is strange is not a good enough word, Malas. This is amazing. And even taking this letter as it is, we do not know on what the governor acted. We are on the ultimately governor's sanction must go. Governor's sanction must go for all these reasons. We have no idea what he acted on, apart from, of course, never sending us a show cause. And that point I had made last time without knowing about this letter.
So you have to say that on this he asked for sanction. Just read this and say on this 376 he asked for sanction. Now he is getting intelligent and saying what just read.
Now, Malas,
But one,
let me go.
sorry, one clarification.
Yes.
17A, does it contemplate issuance of a show cause notice against whom sanction is, approval is sought? Does it contemplate?
Well, it's
Application of mind will consider, but the submission that you're trying to make is governor has referred to these two and show cause notice was not issued.
it was
That-
issued.
No,
We also
only against one
the
complaint.
principle
Whose
of issuing R3.
R3's
But the
complaint.
principle of issuing show cause is accepted by the governor himself.
No, true, but whether law requires is what I'm.
Therefore, Malas, I would say yes, natural justice. Your Lordship now, Malas, has Malas, let me digress for 2 minutes. For the answer, I'll be dealing with it separately. Let me digress. This is a direct question from the bench. I'm obliged to, Malas, digress for 5 minutes and answer.
Yes.
Well, it's not now, but from 1967. Your Lordship has this felicitous phrase, adverse civil consequences in
Yes.
Bina Pani Day.
Yes,
And your Lordship did not have very big constitutional principles in 1967.
yes.
When your Lordship elevated saying all this quasi-judicial, judicial, administrative, we go by adverse civil consequences.
Mm.
That is 67. Now, Malas, your Lordship has travelled a distance, 2 recent judgments, one of which I had the privilege to assist the court. That even, this is exactly the same argument raised, Malas, that before you declare an account fraud, not Malas NPA,
No, fraud.
fraud.
That has serious civil consequences.
This
Notice has to be there.
Malas, no, the argument was to declare it as fraud is like filing an FIR. You don't need a show cause. There was a specific argument of Solicitor General who opposed me. It's recorded.
That is,
Now, Malas, the FIR, you don't require a show cause.
no, FIR you don't require a show
The
cause at all.
argument is that before you declare criminal fraud, an account beyond NPA, you don't need natural justice. And the people in that batch, which we argued, Malas, were apparently allegedly owing hundreds of thousands of crores. The court set aside a batch on the principle of natural justice. My answer to my lords, respectfully, is that natural justice is now elevated to an Article 14. It's now part of Article 14, which is not earlier. Today, Malas, when you do something with very serious, the most serious adverse civil consequences, you are granting sanction to a public servant, in this case, the highest public servant of the state.
Approval.
No.
Oh, sanction is also mentioned.
No.
Yes.
Sanction, oblique approval, let us call it. You are granting to the highest executive of the state And you are yourself treating as show cause relevant, but you forgot to talk about the other guy. You did have Mala's relevance in the first chapter. Therefore, Malas, you should have dealt with it. On balance, as of today, the law would Malas be interpreted in my favor. But here, Malas, I'm on something else. To come back to the point here, Malas.
No, I thought it fit to ask you that for the reason that no notices were issued on these two complaints is what you said.
Malas,
That's the reason.
The reason is this,
Yes.
that he felt that he had issued one. Malas, the reason is hurry and lack of application.
That's fine. Yes.
That's the real answer.
That.
Let us be practical, Malas. The real answer is that.
Yes.
I got a complaint. I must proceed. So I issued notice on that complaint to him. I got two more. I said, I already issued a notice for one. I don't bother about all these technicalities of law. Let me pass the order as quickly as possible. That's what has happened.
All right. Well,
But Malas, I must now come back to this. This is
yes.
very, very interesting.
I wanted clarification.
No, I'll be
That's
dealing with that. I'll cite Dharampal Satyapal and Rajesh Agarwal. I'll
Yes.
cite those two judgments because the court has gone very far there on natural justice, telling your lordships how important it is. Therefore, there are three. One more thing I want to say on natural justice before I come back to this. There are three categories. Category one is the category where expressly the statute excludes natural justice. There are many statutes like national security, atomic energy
Those,
plants. Your lordships there alone. The second category is where you expressly include natural justice. There is a third category which is the most interesting. The silence of the statute. Your
Then we will have to read into the
in
statute.
Maneka Gandhi, your lordship quoted the very nice words of Hooper versus Wandsworth. The common law will supply the omission of the statute. That's the principle. In the interstices of that gap, you will read in natural justice. And this is, whereas nobody can doubt, is the most serious of adverse civil consequences. So you must read into this. Here the governor has acted on that basis. Only that he has not issued show cause notice on X and Y, but he has issued on Z. So there is no question about it in this case. But let me come back to this intervention by Mr. Raghavan just now.
Yes.
Well, your lordship will see the number of occasions and how strange this is. You have now, just now told your lordship that I did apply for sanction. Right,
Yes.
Wallace? And this document which Mr. Singhvi is reading is of course not the sanction because I'm reading a document that doesn't seek sanction. Now, Wallace, this document I read just now, I didn't read one friend in Kannada, Wallace,
Yes,
is actually attached to the objections, right, Wallace?
it is.
Now let us see what the objection says. It says this is the application for sanction. This is the problem. When you make up the story as you go along, the problem is this, fellas. Truth has a very strange way, Malas, of getting you caught up in all kinds of webs. Now, let's come to para 55. That was the intervention 2 minutes ago. Now, you should see what your deponent has said.
Para 55.
Yes, page 43.
Mm.
43 of what? Sir?
What is this?
Objections.
Private complaint filed here. Before
Ah,
trial
where?
court, which is here, is the next year before trial court. In fact, talk of 31/7 October.
We are now considering a proposition. Just note one of these 4 dates. The original complaint by application by Mr. Ibrahim, that is R3. Then Malas, the application by Mr. R5. Then the order of sanction, show cause. Then the sanction order. Then Malas, my petition to your lordships and detailed hearing on that. Then 2 days ago counters, and then today's hearing. In between, there is also a police complaint filed, Malas, PCR. None of them mention 31 July. I forgot to mention on 8th of August, PCR is also filed. I'll give you a list
There is no mention about this.
of this. But the mention in the affidavit, which will prevail on pain of perjury, is this, para 55. We have to go by this, not by Malas, what is said orally. Since the accused one is the present Chief Minister of Karnataka, the competent authority to accord sanction for prosecution is His Excellency. This is the averment to which this is annexed. The competent authority to accord sanction for prosecution is the Excellency. Accordingly, the complainant has also sought for the sanction and permission from the governor under 19, under 55, under 197, under 218, under 200, which is pending consideration. It is pertinent to note that since the allegations against the named accused persons are not in relation to any action taken or recommendation made by accused one or other named accused, there is no requirement of prior permission of approval from the competent authority under 17A. This court can consider the complaint on merits without any legal impediment. The copy of the same is appended as 35. This 35 is 376.
Yes.
Whereas I counted 6 dates from the first date. Again, whereas I'm not meaning facetiously, there is a saying 6.
This year is 28, all the rest of documents are there. There's no 317 here.
Give me the date of the application, 2 applications. Whereas in between these dates, write down the dates in a piece of paper. Write it here. In between, on 8th of August, I forgot to mention, a PCR is filed before the trial court. And Malas, that PCR on 8th of August,
That is where you read from. Para 55 is the part of that complaint.
that's right.
Yes.
It's an X there.
Yeah. No, no. Now you read 55
Yes,
at page 43 of the objections. That is a
That's
part
right.
of the complaint itself.
that's right.
PCR.
And it is not, Malas, noted anywhere about 31 July. Stop this.
No, all the documents say there is 317.
And Malas, the document index, what is this volume?
It's the same R4.
Malas, this R4's reply has a list of documents which runs up to Malas serial number 35. You see the list of documents. Obviously, I can't show negative. There is no 31 July whisper of a mention.
That's not there.
Therefore, Malas, this by itself, Malas, again, I'm sorry that these are Malas, analogies which are arising from the natural course of conduct done by the respondents, not me. But there's a saying, the first time it is happenstance. Second time it is coincidence. Third time it is enemy action. This is the 6th time, not 3rd time. Therefore, Malas, 17A today on R3 and R5 has not filed any reply. And I don't have any documents about him. Today, Malas, is clearly. Then, Malas, the 4th sub-aspect of 17A is a very, very strange and quite amazing aspect. The argument is that this offense allegedly took place in Malas, whatever, 2005, 2007, 2010, whatever date you take. Various dates can be. In 2010 or 2005, etc., you cannot apply 17A retrospectively.
That's his submission.
Whereas with great respect, this argument has to be only stated to be rejected. Because if you choose to file a complaint after 10 years, 15 years or whatever years, and then you have it both ways, I will file a complaint today but not comply with the law of the land today, which is of some, well, as hoary antiquity already now. Then, Malas, it's an argument which has to be stated to be rejected. These are, Malas, my 4 or 5 sets of arguments on 17A, on which I submit alone, not that this is the only ground, but Malas, alone, this entire thing falls to the ground and should be, Malas, set aside, etc. Now, Malas, the next point I wish to come to, Malas, is to remind your lordships about the statement made by the governor just now, a little earlier, saying that, look, I don't wish to file any reply. Your lordship remembers that we had said that the governor has specific names and dates with investigation, after investigation of Malas complaints pending. And if your lordship will turn to Malas, well, I don't have to give your lordship the note, just note the details, Malas. Annexures from 693 to 696 and 701 to 702. These are much prior complaints in some of which investigation is complete, charge sheet is filed. Names are Malos Sashikala Joli, Murgesh Nirani, H.D. Kumaraswamy,
Charge sheet is
Jonathan
filed.
Reddy.
Charge sheet is filed.
Investigation is complete in any
Complete.
case.
Charge sheet is not yet filed.
In one Malos, I'm told. In one
Because without sanction, charge sheet cannot be filed.
take out details. Yeah, but it's investigation complete, therefore a charge sheet is filed subject to the sanction. That is the correct.
Charge sheet is also filed.
Yes, yes. Yes, yes.
All right.
Today, Malas, when I say that anybody comes to you and you immediately grant, well, the person who granted has at least these 4 names I have given. And the pages are Malas 693 to 695, then 696 and 701. This is an article 14 point straight away staring you in the face. Now, Malas, there is no reply and none. And in fact, last time orally it was said, orally, that we will let you know about this. Specifically said.
No,
Now-
he has now also said that he will produce the records completely.
So, Malas, that is, no, but the fact of the, correct, no problem. Records are between the court and there, no problem. But the fact of the matter is that these 4 are actual real human beings, actual real complaints and applications, actual real pendency, much earlier dates, investigations complete. That's all that I'm saying. I don't think the record, whatever is produced, can be different. Now, Malas, the next aspect is another simplest, straightforward point without meaning to over-amplify or oversimplify. The sanction must go. I'll tell you why. Your Lordship has now held absolutely crystal clear that sanction is fully reviewable. That is beyond doubt. The law has got well ahead of that. It's completely and totally judicially reviewable. The 2 judgments amongst many Amalas, Mansukha 1997 and Yedurappa 2015. My compilation has them. I'll just take your Lordships to them. So it is completely reviewable like judicial review of Malas administrative public law action. Be it Malas for ulterior motives, lack of application of mind, Wednesbury unreasonable, etc., etc. My Lord knows that well. There is, apart from that, Malas, I have given detailed additional law also, and I will, Malas, cite some of that. Well-established principle. Rameshwar Prasad, State of Gujarat, R.A. Mehta, and of course, very homely flavor of Karnataka, S.R. Bommai. Directly, Malas, they say, it's fully reviewable. I've got the paras also. 9 judges down to division benches. Now, Malas, the beauty of this case is that the governor has not applied his mind or dealt with a single point on the merits of the sanction. I repeat, that's why it's a simpler case. Not applied his mind or dealt with. Whereas you can even deal with the subject, which shows that you've dealt with it without applying mind. It is possible. But for not applying mind, for me to show non-application of mind, I must show that you've dealt with it. The governor has not dealt with a single point. One point he deals with. I am not bound by the cabinet advice. So let me for a minute accept the Honorable Governor and proceed from there. I'm not accepting this, but I'm just saying, please proceed for a minute. You are not bound by the cabinet advice. Let us take it as it is. Therefore, you are acting on a tabula rasa. The tabula rasa is that this man has applied, this application has come.
No, this requires an independent decision. Sanction against this, the chief minister or other
Therefore,
functionaries.
I'm for a minute
It is
accepting.
an independent decision of the governor. He cannot fall back upon or need not fall back upon the advice of the ministers.
I am Malas proceeding on that basis.
Yes.
There are some nuances in Navam Rebia.
Ah,
It is, but I'm not arguing that. I want to make it simple first. For a minute, please assume against me and in favor of the governor, as my Lord felicitously put it, independently decides. He's the cabinet, not bound by the cabinet.
yes.
He's the complainant. He or she comes to me. I'm the governor.
In this particular issue,
Yes.
not in every issue. He is definitely bound by the bound
No,
or
we
to
are
follow
talking of
aid and,
sanction. We are talking of
aid and
sanction.
advice definitely is there.
No,
But
on
in-
the sanction
On the
regarding a
sanction-
chief minister.
Yes.
So Malas, we need not trouble ourselves for a minute. For this purpose, at the moment, I am assuming against myself. So Malas, what happens? I'm the governor. He or she complains. as a lordship used the word independently, I have to give. Now turn to page 41. There's nothing.
No, that will,
There's nothing.
that you have told. Yes.
What do I show your lordships? There is nothing. There is only one point. I received a complaint. I received an advice. I am not bound. Hence, I grant sanction. I don't want to exaggerate, but I repeat. Is that not sufficient to quash the sanction? My lord used a milder word just now, independent.
No,
It has to be an
independent decision-making.
objective consideration with reasons, with application of mind reflected in the order. There must be something. It can't be that because I'm not bound by you, therefore I must grant sanction. That's what the order says. Therefore, my lords, this on the merits is the most strong ground on the merits of the sanction I'm now. And it is sufficient to set it aside. Now let's
Yes.
just pick up that, only the index. I'm not going to read it. To
The
let's give the index. of the
judgments?
Yes, lords. Just to tick it, just so lordship knows where is what. Is it all here? Where is sanction is reviewable? Sanction is reviewable. Where? Which one? The index where? Well, let's,
Here.
there are some of them which are separate, so I have to little scattered. May I make my lords just stick it? In this large bunch, one is scattered at serial number 2 at,
Acha,
I'm sorry, you should not have put new serial numbers every time. Why do you make an index like this? Not the index. We have put Wallace fresh numbers each time, so it creates some confusion. If your lordship sees Wallace page 2.
Page 2, sir.
Of the index.
Yes.
So one is Wallace Mansukh Vithaldas Chauhan.
Next is.
Yes.
And the paras of this Wallace are. The paras don't make me wait. You are a
Para
complete
14,
mess.
17, 18 and 19.
Para 14 to 18. In fact, 14 to 19.
Yes, sir.
Take out. These are
Of
para.
Mansuklal Vital Das.
That your lordship has picked Wallace number 2. I'm sorry, our index should have had continuous numbers, but we don't have.
No, that's
it's
all
number
right.
2.
No problem.
Yes.
Yes.
Then Wallace
20.
Yedurappa
22 to
is on the next page, number 5.
22 to 30. 22.
Yes.
Here, Wallace, para 22 to 30. But I have also culled out the more specific paras like 27, 28, 30. Wallace.
Yes.
I will also Wallace, give a lordship a digest of just the paras with the extracts to make it shorter later on.
That's better.
That. Will you make a note of that? Just not all, just the relevant ones, the underlining highlight. Just, it's much easier. Now, Wallace, in addition to that, point 11 below. The other judgments, Wallace, which talk of judicial reviewability very clearly is the Constitution Bench of Ramesh. Where is the bunch?
Yes.
This is Wallace, a volume 2. These are high-powered numbers in terms of benches. Wallace. The numbers are larger. Constitution benches are 9 judges.
Yes, sir.
So one is Wallace Rameshwar Prasad, which is the number 4 serial on the first page.
Yes.
Here your lordship may write on the margin, I'm sorry. Maybe I have to give it to lordship writing. But it's 128 and 129. This is a constitution bench, 5 judges.
Yes.
And Wallace 140 to 145.
Yes.
Para numbers. Previous 2005 Rameshwar Prasad, para 7 will suffice.
Yes.
So 2 Rameshwar Prasads.
Yes, sir.
Both are constitution benches. Well, the state of Gujarat. State of Gujarat. Well, I'm very sorry. What we'll have to do is extra, because we've given them all over the place. So I'll give the
It's all
extra.
right. No problem. Yes.
There is well a state of Gujarat, which is 2013, 3 SCC, page 1, para 68. I had the privilege of assisting the court here.
So all of these are concerning Article 356.
So, Malas,
What is that you want to rely on?
so I'm saying, Malas, governor's actions.
Huh.
The narrow ones I've given you first two are Mansukha and Yedurappa.
Yes.
But Malas, I'm saying governor's actions are fully reviewable even in the A for sure I category,
No,
totally and
I
completely.
have no doubt about
That's right.
it.
That's
Yes.
it. So I'm just, Malas, this is 45. That's why I'm not reading it.
Yes.
I'm not even reading it, Malas.
Yes.
I'm giving a lordship decided and it's capped. It's capped by Bommai in Malas the paras. So what I'll do is, with your lordship's permission, I will take Malas extracts and only some of them and underline them and give it to your lordships. I am not even reading them.
Yes.
It's too well established. Now, Malas, on the natural justice part,
Same confirmation.
Please note the 3 dates first. Whereas note 3 dates, a show cause is given to me on 26/7/24, which is at page 265.
Yes.
And Malus, what? Date of my reply. Date of my reply. And Malus, meanwhile, in the interstices of the government, the AG has given an opinion on 31st of July 24, as the documents now show, at page 267. And the cabinet note is at 1 August 24, which also attaches the AG's opinion at page 336. But what is missed out here is that I separately replied on 3rd of August 2024
Page 60.
at page 630. And I also cited a lot of law and all the details, etc., etc. Now, all of this is decided by the order at page 41, dated 16th of August 2024, which, as your Lordship has already noted,
Yes.
adds this gratuitous sentence that R4 and R5, which is para 2 of that document, page 41, para 2, which is when I first learned of it. But this is one part of natural justice. Natural, very many parts. This is A. Part B of natural justice is that all the points I have raised, forget the cabinet, you're bound or not bound, I'm not bothered. I have raised these points of diverse nature. You have not dealt with any. That's point number 2 of natural justice. It is, your Lordship has the order 41 to 46. I can't add to it. I can't subtract to it. Nothing. Files also, which are uncommunicated, can't, as far as the final order is concerned, add reasons. You can't say that I wrote an order like this, that I had 28 reasons in my file back home. That is not an order. You can't justify, Now, in this light, your Lordship put a question on the scope and nature of natural justice. So before I read those 2 judgments, take them out, keep the paras ready. I want to just give your Lordship first principles, 3 or 4 points, then your Lordship will. One is adverse civil consequences, Bina Pani Day. Second is the consequences here are much beyond adverse civil consequences, because it is not only the person who is the chief executive of the state. I have said in the opening that the larger constitutional issue is that if you are elected with a full-throated election where huge amounts of money are spent by the opposite side, but still you lose, somebody is elected. He may be bad governance, he may be a horrible governor. Only the people who elected have a right to remove him. If you can use this methodology to remove him or initiate removal, then it's a negation, which is why all safeguards have to be read. Obviously, if somebody is steeped in crime and you have material, yes, give reasons and start removing him. But every filtered safeguard must stand at the threshold, because you are negating the mandate of the people. If you accept this larger principle, and your Lordship state, Karnataka, was the first to make basic federalism part of basic structure in Bombay. It's very interesting. We digress for a minute, Federalism, if your Lordship Googles the Constitution, is not a word found anywhere in the Constitution. I gave a lecture once, I examined it. There's no word called federalism. The word federal comes up because it's a federal court we had.
No, because we are quasi-federal.
No, that's all right. But even quasi-federal has some elements of federalism. Kenneth Weir called it quasi-federal. First Australian jurist to use it. But federalism, you only get reference in the text of the Constitution to federal court or federal. Federalism, without being mentioned in the Constitution, your Lordships and 9 judges Bombay held to be a part of the basic structure of the Constitution. So, this is another aspect of assaulting federalism or negating federalism if you can remove elected chief ministers. The third, which is why your Lordship must read in all safeguards. Third aspect is that famous phrase of Mr. Ambedkar. You cannot have 2 swords in one scabbard.
That you told me.
Elected, yes. Unelected. Therefore, keeping that in view, your Lordship will just see in natural justice, you are having a plethora of material which you in your independent sovereign decision making has a right to overrule, but with reasons, with material, with thinking mind. Nobody is grudging you a right to act, but we are grudging you a right to do it in a proper way. That is what natural justice is, not hearing only.
Decision-making process.
That's a much better word for. Oh, I heard you. I sat like a sphinx, like a statue. I heard you. Now go home. I've written the order already in my desk. I take it out, give you the order. That is also natural justice. I heard you. It's not hearing. It's the decision-making process, that's exactly the correct word. Now, in the light of that, turn to, well, it's this.
Please give this thing.
No, let's first turn to Rajesh Agarwal, paras, which is, well, 2023 6 SCC, page 1. Kindly hand it over to me. You give me this, then you come to mark copy.
Because you mark it, this is the things you're given to judge.
Volume 2, Malaz.
Yes.
Now, let's just kindly note, I chose this first, not because I appear in it, Malaz, but because the facts were purple. They said that these are defaulters for whom I was appearing, who have crores and thousands of crores, and they must be declared fraud. But they're very interesting. RBI circular says NPA is one part, but you must declare them fraud so we can take criminal action. Now, the process of declaration of fraud, they had already got notice about NPAs. Natural justice was satisfied. Bank said, why should we have another natural justice? We've already declared them NPA. These are fraud people. So they declared them fraud without natural justice. Now, the arguments for us, therefore, are very useful in that light.
It's para 36 onwards.
Yes, I'm grateful. And Malas, this went on for quite a while while President Chief Justice was in court too, Malas. He was
Yes.
the senior most puny judge. Starts with 41, if your lordship will turn for a minute, Malas. Audio alter starts with 36, my lord rightly notes. But come to Malas page para 41, which is the Bina Pani Day. That's why I don't have to cite all of it.
Yes,
Lordship
yes.
gets it all there. So this is how the court, Malas, your lordship applies natural justice in the larger decision is a subject neutral concept. It is subject neutral. It cuts across the entire law. Then was 42, Canara Bank. Administrative actions involving civil consequences. And see the italicized portion at para 45, italicized by the Supreme Court, not by the SCC. Even an administrative order which involves, so administrative order also. You are talking of much more serious orders here. This is not administrative order. Then let us come to 46. Consistent pattern, not merely property or personal rights, civil liberties, material deprivation, non-pecuniary damages, every order, civil consequences. So, Bina Pani Day is the anchor which is now built upon very much widely by this judgment and other judgments, very much more widely. Now come to 67. That master circular of RBI starts at 48, etc. I'm skipping all that and bringing.
What is held it as para 81?
Well, that's true. I just want to take 2 minutes more on 67.
Sir.
67.
Exclusion of.
Now,
Right.
this is that principle, express exclusion, express inclusion. But you must read into it the interstices. And there, Malas, your lordship will see Swadeshi. Just see, Malas. Just see the third line of 67.
Yes.
This is what I was saying, Malas. It's taken from that Cooper v. Wandsworth.
Yes.
The common law will supply the omission of the statute is the principle, where it is silent on granting an opportunity of hearing to a party where rights and interests are likely to be affected. Then Swadeshi, then come Malas to the next page. See the first few lines of para 44 quoted at page 37 of the SCC. In short, the general principle as distinguished from an absolute rule seems to be that where a statute does not in terms exclude this rule of prior hearing, but contemplates a post-judicial hearing amounting to full review, then such a statute would be constituted as excluding the audio alterum at the pre-judicial stage. Conversely, the statute conferring the power is silent with regard to the giving of pre-judicial hearing to the person affected, and the administrative decision taken by authority involves civil consequences of grave nature, and no full review or appeal on merits is provided. All of it applies to me, Malas. All of it. Courts will be extremely reluctant to construe such a statute excluding the duty of affording even a minimal hearing shorn of all its formal trappings. Your lordship is in Malas at the worst in virgin territory where your lordship must lean in my favor. Is my humble submission, reading the way it is written, Malas. Yes, if there's a exclusion, different matter. The court must make every effort to salvage this cardinal rule to the maximum extent possible. Then Malas Swadeshi goes on in 69 and leave that and come to Malas 70. Mangilal is important, Malas. 70.
Yes.
Even if a statute is silent and there are no positive words, kindly see this, Malas.
Yes.
In the act or rules made thereunder, there could be nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by the orders that will be passed. and making it a requirement to follow a fair procedure before taking a decision. More important is fair procedure, not only well as the formality of the hearing, as my lord rightly put it, decision-making process, and making a requirement unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute unless there is a clear mandate to the contrary. No form of procedure should ever be permitted to exclude the presentation of a litigant's defense or stand. Then, Malas, 5 lines later, where the statute is silent about the observance of the principle of natural justice, statutory silence is taken to make compliance with the principle of natural justice, where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by express words of statute or necessary intendment. Its aim is to secure justice or to prevent miscarriage of justice. Principle of natural justice does not supplant the law, but supplement it. Then, Malas, look at the argument of RBI. Malas, I had the privilege of arguing for the respondent, which succeeded. RBI and lender banks have contended that the principle should be excluded in cases where there is promptitude or exigent action. Then, Malas, I'll skip that and come to Malas, para 74. Swadeshi. They Malas, distinguish and apply. They do both things, Malas. Then 78 is Kesari. Now, Malas, now this is on that investigation. Your Lordship doesn't need to actually give natural justice in that sense, is the commonly assumed belief. But they said, no, you must give all the material. Please see. In Keshav, this court was dealing with the issue of takeover of the company after completion. These are much minor cases compared to what is happening to this man here, the petitioner. Much more minor, I would say, in relative terms. Completion of a full investigation into the first. The issue was whether the report of an investigating body appointed by an administrative authority should be made available to the person concerned before the authority takes a decision. Your Lordships could brush aside a case diary. It's an investigating agency. Don't give it to it. What does it matter? No. The court said, no, you must give it. Well, just see page 41, where they say, unless the report is given, the party cannot make any effective representation about the action that the government takes to pursue. Malas, what I would have said in addition regarding R4 and 5 is up to me. You never gave it to me. Then Swadeshi again is cited. Then Malas, Tulsiram Patel is 80. I will skip that. And Malas, then come to straight away 81 onwards, Malas, and then finally 89. You put here 89, it's only 85. 85, Malas, is fairness in action. Now, this is a larger principle of natural justice. Is it fair? What is this tearing hurry if you've got 12 other complaints or 6 other complaints pending? Why this tearing hurry? This is all your holistic approach. But the Lordship, the writ court looks at it holistically. Fairness in action requires that procedures which permit impairment of fundamental rights ought to be just and fair. The principles of natural justice have a universal application and constitute an important facet of procedural so-and-so. Violation of Article 14, etc. Now, the natural justice is not part of Article 14 in the early years. Now it is part of Article 14. The most powerful article in our Constitution, I would say even higher than 21 is 14, but at least on par with 21, 14 and 21 are the two Malas, most biggest Brahmastra which this Constitution has. Then Malas, para 89, the Lordship says that even a statutory provision should be read to lead in favor of natural justice on the other hand. That's 89. And then Malas, CB Gautam was Malas, is a very good example. The Lordship knows 20C, now it's gone. Compulsory takeover of property.
Yes.
Why should you have to give notice, Malas? You are almost dealing in a quasi-penal context. You are Malas, saying something is wrong with your income tax returns, we are taking over, etc., undervaluation. Still, and this was completely Malas, not there in the Act 20C which was introduced. See what the court says, Malas, para 90. Whether a show cause must be issued to an intending purchaser and seller of property before making a compulsory purchase. Chief Justice Kania said that where the validity of the provision would be open to serious challenge for want and opportunity being heard, courts have read such requirement into the provision. And here you have a judicially reviewable. Malas, what is the point of a Lordship judicially reviewing something between the governor and your Lordships? The man affected has no role in it. What is the judicial review Lordship will do, Malas? Only just whatever he has said, your Lordship will sit on that. He has no Malas. The learned judge will have no input from me to the governor. And then Malas, it goes on. And then ends Malas in please. And then Malas, they ask you in 94.3 and 94 to say you must first follow the fairness, then pass a reasoned order. Now see that 93. It has been elucidated in the preceding paragraph that the classification of a borrower's account as fraud in accordance with the procedure laid down in the Master Directions on Fraud, entails significant civil consequences for the borrower. Since the Master Directions on Fraud do not expressly provide an opportunity of being heard to the borrower before classifying an account, the rule of odd alterum partem has to be read into the provisions, etc. Then, before concluding, we also want to address the argument by the borrowers that the requirement of passing a reasoned order must be read into. They relied on JAR developers where it was said that this must be made by a reasoned order. And then, they say, of course, you must give reasons. But of course, it's not like I'm asking you to write a judgment. You're not a judge, but you must give reasons broadly. That is okay. I mean, nobody's saying that you're a judge who has to give a reasoned judgment. Well, to the same effect is the more general case, which has been cited now in all your lordship's cases, including this one, Dharampal Satyapal. That is 2015. In the compilation, it is the previous one, 2015, 8 SCC 519. 27. It's a frequently cited judgment.
Yes.
It brings to speed all the case law on this. Now, one of the other facets is, so what does it matter even if you heard me, the result would be the same. Lordship has dealt with it long ago. Now, even if you hear me, result would be the same. Why should I waste time hearing you? See, 42. Important question posed by Mr. Sarabji is as to whether open to the authority which has to take a decision to dispense with the requirement of the principle of natural justice on the ground that affording the opportunity will make no difference. To put it otherwise, can the authority dispense with the requirement of issuing notice by itself, deciding that no prejudice will be caused to the person against whom the action is contemplated? Answer has to be in the negative. It is not permissible for the authority to jump over the compliance of natural justice on the ground that even if hearing had been provided would have served no useful purpose. Because Gandhiji's old dilemma, means and ends. He always insisted on the means for us. Ends are okay, but means, that's important. Then 43, they again affirm that principle of prejudice. One is that no difference would happen. Second is prejudice. Both are affirmed. We still need natural justice. And then it goes on, to deal from para 41 onwards to 44. And ultimately, they give primacy to natural justice. Now, my next point relates to as a reminder for 2 minutes only of the very remarkable dates in this case, which your lordship noted with me last time. Lordship notes will bear it out. There are very few dates. May I just remind you, lordship, those 6-7 dates? Correctly typed? Well, I had oralized it, lordship, and
Yes.
I've got a 1-pager just to put it on this here. Give to other side also. Same person. Well, these are all in Kannada, but of course we have Kannada experts here. Well, 1992 is the notification. 98, it is denotified. And right through, not a single file.
No. What happened after denotification?
This what is coming up.
Ah.
It's coming up. I'm just saying one general thing, not a single file came to him in any capacity as Chief Minister, Deputy Chief Minister, or the relevant minister.
That
He was never holding that portfolio. Never. Survey is denotified through the government notification. Then 3 is 2004. Records show the change of land ownership from Devaraju. First was Ninga. Ninga's son is Devaraju. And finally comes Mallikarjuna Swami. Now, Ninga and Devaraju, which is for 20-30 years earlier, have no connection, no relation with the Chief Minister. None. In 2004, the sale deed comes to my brother-in-law, whose name is Mallikarjuna Swami. That is 2004. So the entire sequence of denotification, purchase in auction, denotification, acquisition, etc. is all before it was anything to do with me at all, with my family also. Much later in 2004, this brother-in-law buys it from sale deed. Then 2005, conversion is done. Gift deed comes to my wife in 2010, his sister. And then, Malas, in 2014, an application is filed to allot an alternative area because, Malas, no compensation. Malas, because the admittedly that whole thing has been Malas used or Malas, otherwise encroached upon, etc., or dealt with. So they say, look, this whole thing will to reverse the whole thing and to give Malas pristine land again. Therefore, alternative is asked. It is done for a large number of people, and then 2020 and 2022, the sale deed. This is one of the broad picture. Today, you are having in 24 some kind of a outburst as if some massive scam has happened, which is not open to anything. This is just a perspective. I repeat, I repeat with great respect and humility, and this is important, I should have said so in the beginning. And I'll be making it as the first point in my rejoinder when I file it. I am always dealing with these facts on and off because I don't want my lords to feel in conscience that I'm suppressing or avoiding anything. But I'm very clear that these two counters we have received yesterday in day full of facts, as if your lordship is hearing a criminal trial. Now, my respectful and humble submission is that I am not required to answer a single fact. Don't misunderstand me. When I give your lordship these dates, they are landmark dates. I am A, not required to, B, I am not obliged to, C, I am not going to reply to these facts. Why? Because the issue is the sanction.
ಈ ಖುಷಿ ಇರ್ತಲ್ಲ ನಾ ಸೋತೆ ನಾನು
Yes.
Now, I am not required to do that because the validity or otherwise of the sanction depends on the argument of the applicant, the argument of, if I may call myself as the non-applicant or the objector, and the governor. There is no list in a counter affidavit in the High Court that your lordship will give a civil or a criminal decree on these facts. Your lordship will pass a criminal law order. Your lordship will find a guilty. Your lordship will give a civil decree. This is not the job. Question is what you are today, this is important, Malas, what you are today arguing in these two objections full of facts is not what the governor did. Is not what the governor did. The governor passed a simple 4-page order. Today, you are not a super governor to justify that governor's order by giving all these facts.
No, it is on the basis of their requisition sanction is granted. So
Correct.
they are defending.
No, of course they will defend, I understand. But I'm just saying, my necessity to rebut individual facts, to say that, look, this is criminal, this is not criminal, this is culpable, this is not culpable, doesn't arise. Because your lordship has no reasoned order. Yes. Suppose the governor had passed a reasoned order. Lordship has dealt with many cases like this. Sanction is not a new thing. Governors pass reasoned orders. Then possibly I'd have to say, look, this is where the governor has said 2 + 2 is equal to 5. And he's wrong. Because on that date, did not exist or something, something I could say. But there is no need for that because there is nothing to, I'm not here to answer a list on a civil or a criminal side with the private people, complainants. That's the perspective I'm urging my lords to keep in mind. So whatever I say, I say it really more from the purpose of disabusing and creating the fact that your lordship is, I'm not keeping away anything, but not because I'm obliged to or required to in this proceeding to answer anything. The facts, otherwise, just to end on the facts, show the overriding point that public servant whom you are seeking to prosecute. Has your lordship ever seen a public servant? And now, of course, we have repealed that section also in the PC Act, where for this long period, when this person was born, this brother-in-law, in which year? Which year the brother-in-law by? 2004 till now. I have never dealt with the file. I'm not the portfolio minister. I have never passed any order, and the decisions taken of denotification otherwise have been passed for a number of people, not for me alone. And yet after 20 years, 24 is 20 years after 2004, this is happening. So that has to be kept in perspective.
He also says this, that he is not in any manner that the commission to charge more prosecuting. He says so.
No. Now, the other aspect is, this 218, your lordship's old 197.
Yes.
Broadly. Now, my short point, this is more or less what I said earlier, because nothing major has come for me to deal with in the counter. But broadly, the points are threefold, if I may ABC tell your lordships. Well, the granting is under 218 also at page 47. The lordship noticed that last time,
Yes.
page 47 specifically. Now, my lords, this section has to have some specification of the ingredients of the offense. What offense, how offense, which way the ingredient of that section is fulfilled.
That's
before you
quasi
get-
sanction.
That's right. So, Malad, I'm just saying that specification is nowhere there. I am not concerned. I'm not saying that you had to grant. You didn't have to grant. It's possible to say, I don't have to grant now, I'll grant later. That's not what he's saying. He has granted. My question to myself is, he has granted on what? Well, the ingredient, I say 420. So you have to say that I am granting for 420 because in this way I came to him, I represented to him or misrepresented, I got movement of property, etc., something. There is nothing. It's established that 218, etc., must make out the attempt to make out at least the ingredients of the offense. That is missing. That's separate, Malus, and independently as fatal as the submissions I have made, Malus, regarding 17A.
Yes.
Now, Malus, I'll just end in a minute. Give me. Well, may I say that since I've argued most of the matter, let me just note the paras. It's a
Of-
more intellectual.
judgment?
No, so I've done with the matter, Malal, as far. I'm just, Malal, since it's more of an intellectual thing, I'm not arguing it. But Malal, this submission that he's not bound at all may be a larger legal issue. which
Not
your
bound
lordship
of
may-
what?
By the cabinet.
That will.
That let me oralize it for
So
lordship.
that's a
I'm
prima
not,
facie, we will see.
Yeah,
Yes.
but well, only why I'm saying it, Your Lordship. Well, there is a judgment of MP establishment which suggests otherwise. As simple as that. My learned friends rely on that. Now, well, Nabam Rabia, which is a constitution bench,
Para 156.
is the conclusion.
Yes.
But it cites, well, the conclusion says you can only act in your own discretion in 3 cases. It lists them. I read you last time, 156. 155? 155.
155. right,
Now,
yes.
admittedly,
Yeah.
this doesn't fall on those 3 on the text. Clearly. Now, MP is also 5 judges. Nabam is also 5 judges.
Yes.
Nabam is later.
Later.
But Nabam, with the conclusion in 155, saying only these 3 categories in which we don't fall, cites fellows MP in 7, 8 paras. Just note the paras because it's a very long judgment.
Yes.
140 to 142.
Yes.
You don't say what these paras are. I didn't say stop in between the sentence. I'm sorry, but just cut out that para. It is cited in the following paras, Manoj. 116, 118, 128-29, 315, 317, 2 more paras, 326 and 337, and lastly 362. Now, a later judgment citing the earlier one and was coming clearly to a conclusion in 155, which categorizes 3 things where we don't fall. At least the High Court Balas should prefer to follow the later one, but that at the moment I don't argue. I'm just pointing out that not that Balas, it's a frivolous argument. I'm not that Balas.
The 5 judges saying of this court.
Yes, yes.
So due to-
And Balas, your lordships have, of course, this is obvious, Balas, I don't need to, a 5-judge full bench of your lordships, Karnataka High Court, said that when there is some apparent variance between an earlier 5 judges and a later 5
So
judges,
later will prevail.
and you will follow that. That's your lordship citation of 1979.
No,
SCC
that's
online. Many of them are there. Whereas I would therefore say that, of course, reserving fully my right to not only file, but to argue a rejoinder fully. This case is a fit one, whereas this sanction cannot be there.
Yeah.
What they do in future, what they find, what is applied, etc. This sanction must go. This sanction actually can and should go on the admission of some of the complainants themselves. But whereas that apart, I'm not dependent on their admission. Your lordship is entitled to say on both counts. It's not that your lordship can say because of those reasons it doesn't stand, but I otherwise go into it, otherwise also find this. This sanction is, well, it must go for the separate reason that there is no reason. None at all. Well, those balance are my submission, very deeply obliged. Well, I reserve all those rights
All right,
because I
yes.
am sure some, in the light of my arguments, your lordship rarely has that I finish my argument, then a new
No, no,
counter
you
will
can-
come,
you
and a
can
new
explain.
angle will come, and the new angle I can't do this, therefore
No,
your
that's
lordship
all
got that
right.
in mind.
Yes, anyone today or
Well, I am ready, my lord, but if the Solicitor General, my lords, it would be appropriate if lords
is
hear
is
him.
there?
I have a
Yeah,
suggestion.
my lord, I'm here, my lord. Am I
I have a
audible?
suggestion which on one of the rare occasions, Mr. Mehta may agree with, I don't know, Manas. It may be a rare day, but he may agree. Well, Saturday, I'm told is a working Saturday for.
Yes. It is.
This Saturday.
Mutual benefit.
Yes,
yes,
this
yes,
Saturday
this
is a-
Perhaps you did not know, Mr. Mehta, so your agreement will be in our mutual benefit.
No, I don't go by the benefits, Dr. Singhvi, but Saturday is fine
Yeah.
with,
Saturday is fine.
Saturday is fine.
subject to Mr. Maninder Singh is also appearing, my lord, my learned friend.
Where is?
Somebody can start. Manas, let it
Yes,
go on.
yes.
I may be
Finish.
permitted to start. Please.
It won't finish anyway, so that's.
No, Mr. Singh, would
Fine.
it be
Let-
possible?
Saturday is fine. No
Yes,
difference.
yes, Solicitor General's convenience is important.
Can't hear.
No, that is 20.
First.
Now, whoever wants to submit, then you will have to resubmit on when the rejoinder is filed if needed.
Please, correct.
But what if you want to submit, you can submit.
Yes,
Please. 31st. We are talking of this Saturday, 31st.
Yes, this
31st, yes, my lord.
Who are you? Intervener? Intervening as what? Petition? For what? Your fundamental right, who has taken away? So first, what is your right that is taken away? Hmm.
Just can I interrupt for 30
No, no,
seconds?
this is not.
There's an old saying, Malas, sometimes, Malas, your friend can be your worst enemy. Please don't think that I have set up anybody, Malas. I am not interested. The problem is, Malas, anybody comes and argues, people blame me.
No, I don't think you,
No, well, this
I don't think
happens.
you need a friend to be set up.
No, Malas, a friend is worse than an enemy sometimes. That has happened many times in litigation.
Where does this road lead to? The caterpillar would say, you don't know where you want to go, it would be there. We'll see, we'll hear. Not in this, it is, no, not.
Lord, if lordships are to start hearing us from Saturday,
Wait, sir, damage will be caused to the state.
No, I would assist the
That-
court on behalf of
No,
the
no, sir.
governor. Thereafter, Mr. Maninder Singh is there.
We are not hearing a PIL here. It's an order of the governor that is called in question by the person against whom the order is passed. Huh? On par with the petition of the respondent. All right, we'll see. Wait. No, your application is, you filed it. We'll consider it. Yes.
if Saturday, my lords, if the Solicitor General wants to start,
Huh.
it would be appropriate, my lord, that he
Yes,
finishes
sir.
it and thereafter I continue.
Yes.
Is
but
there?
if he
Mr.
has
Maninder Singh is also
argue.
there.
We are ready.
Let it be
Whoever-
10:30. I will complete and Mr. Singh can start.
Yes,
Please.
Today,
No, my lord, Saturday, my lord, if you allow.
Saturday. All right.
deeply obliged, deeply obliged.
10:30, my lord, can it be at 10:30?
We'll start it with 10:30 and conclude it. Yes.
Please.
And all of your, the rejoinder later on.
Well, Legion will have to be later because they will be having a lot of things, but
I
one
know.
day more I'll finish it off. One day more.
That's all right. Yes.
So
I'll
Saturday,
take account of everything and make my note also accordingly.
Yes. Let
As
the
single
respondents,
note. Yes.
respondents finish.
Yes, yes.
Hope all of you will finish on Saturday.
as much as possible, we'll finish Saturday.
All right.
Once we allocate time for us, so we know how much time we have.
It's all right.
Each of you.
No, it's all right, my lord.
Each of us will not allocate.
All right. I don't think each of you are saying something contrary to each other.
No, no.
Then-
Absolutely not.
All right.
But two broad issues, my lord, we will address it, subject to what the solicitor.
No, then Solicitor General will start first.
We'll start.
And all of you will
We'll follow.
next follow. Yes. Then we'll do it on Saturday.
Yes.
Yes. Heard, that I will do. That we will do.
Grateful to your lordship.
Heard the learned senior counsel Abhishek Manu Singhvi, who has completed his submissions for the present and would reserve his right of rejoinder submissions once the submissions are concluded by the respondents. The learned Solicitor General submits that
Saturday.
the matter would be taken up on 31st. He would complete his submissions on the said date. Records may be required, sir.
I will keep, my lord, my record present.
Yes,
which
sir.
can be-
Would complete his submissions on Saturday. List the matter on Saturday at 10:30 a.m. Interim order granted on 19/8/2024 shall continue till the next date of hearing. Yes. Wait, yes.
One of the record, including the other application, status of the other applications also, your lordship.
What applications?
You have produced 4 other complaints which are pending.
No, every record will be produced.
Not only passing of this order, my lord.
Oh, you mean from the office of the governor?
Yes, yes. They had said,
The
Malad,
4 applications also. what
I
is
have
the
named them.
status
I have
of
named
those?
those applications.
No, but I'm unable to see who
That
is
is-
requesting.
That is for the perusal of the court. They will do it.
The
Yes.
perusal of the court, my lord.
No, it's my contention, so Lordship can peruse it, of
Kindly
course.
finish.
My
But it
contention
is a
is writing.
state has nothing to do with this, my lord.
Governor
Accused,
has everything to do with.
potential accused and the governor
is the one who
will.
has passed the order, sir.
The complaint that have been referred to by my learned Singhvi are under 19. They are not under 17.
No, I asked the senior counsel that they are all after investigation
Exactly.
and wanting sanction to file a charge sheet.
So there's.
No, the problem is 218 is also referred. That's the reason.
Lord.
And he would say 218 is referred for the reason that
Paper.
IPC offences are there in that.
Right.
That
In
cannot
fact,
be said.
is which?
That should be submission.
Lord, much emphasis, my lord, was laid on pendency of sanction applications, my lord, in connection to 4 legislators, my lord. Now, my lord, pursuant to the dictums laid down by the Honorable Apex Court, my lord, what precluded, my learned friend, my lord, the Chief Minister of the State of Karnataka, my lord, to, my lord, pass directions to approach this Honorable Court seeking necessary directions to the Honorable Governor, my lord. No, my lord, because the governor was termed as a friendly governor. Now, my lord, with all liberty, I would call the Chief Minister as a friendly Chief Minister.
To those complaints.
Chief Minister, certainly, my lord, unlike the governor. Certainly. Now, my lord,
Friendly to the constitution.
my lord, they have quoted pendency, my lord, since so many years. My lord, nothing
No,
precluded
let's
them.
see what is pending and what is not pending. The office of the governor would place the files. We'll answer. The contention is taken, we'll answer it.
Please.
That's all right. That doesn't mean we pay.
No, my lord,
you
now
want
this
to play
vote
a
is
friend-
acting on your head.
No, it doesn't mean you want to play a friendly match here, right?
Certainly not, my lord.
Can I make one request? Can your lordship accommodate me on Monday? The others can argue. So, but I am.
All right, let them finish. We don't know how much time everybody would take. Then when senior counsel Singhvi would again come back, that's on Monday, sir. Monday or Tuesday, whenever you want. The same day we will,
I'm convenient on Saturday, that's reason.
you would require 30 minutes.
No, but I require about an hour.
Huh?
I require about an hour.
All right. So 1 hour each will allocate then. Yes, sir. We'll take it on
Saturday.
Saturday. Yes.
Grateful to your lord.
This on Saturday at 10. And Senior Counsel Maninder Singh sir is also there.
Yes,
That is for whom?
one of the, I think,
He's appearing
complainants.
for, I think,
One of the complainants.
Complaints, all right. Yes. I will record presence ಎಲ್ಲಾರ್ದು record ಮಾಡಿ madam.
I think, sir, ನಿಮ್ ಜೊತೆ ಸಾಗವನ್ ಜೊತೆ.
ಯಾವುದು?
5th response, 4th, 3rd response.
Which? Who? R3 is appearing party in person.
My lord, there was an IA filed, my lord.
You have filed an application?
We are not pressing that application.
Not pressing.
Please.
IA 2 of 2024 filed by the respondent in person. R3 nadu?
Please.
R3 in person, the learned, the respondent in person would submit that he would not press the application seeking to appear as a respondent in person. In that, in the light of the said submission, the application stands disposed as not pressed.
Much grateful.
Obliged to Lord.
Yes.
Grateful.
Madam. Yes, sir.
Please.
On Saturday at 10:30. Then we have the list till. Ellardu kodi, give all the list. Don't miss out anybody like last time. Give all the list. And whenever you give list of authorities, I have time and again told you, you should mention the paragraphs in the index. Correct that and mention or paragraphs in the index and give. I did not want to tell it in front of senior. Yes, do it. Madam, ಬೇರೆ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಾ ಇದೆಯಾ?
Next one, continue.
Lords, till number 41. Lords, IPF for the petitioner, Lords, challenged is the proceedings and for the offense punishable under section 27C of Drugs and Cosmetics Act, Lords. There is no compliance of 23(4) of the Act, my Lords, in so far as.
One minute, madam. Madam, idu Desireddy ittalla ella. ಅದಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಜೊತೆಗೆ. Yes, heard the learned counsel. Idu identical matters Desireddy ಅವ್ರದ್ದು Drugs and Cosmetics.